I go by Julia White for my defense practice. Everybody calls me Janet. That's my first name. My friends do, but I do Julia White for my defense practice. So,
So, what I would like to start off with is a little bit about yourself and your experience. So, I want to know, how did you get into DUI defense? I was reading through your biography, and you've have extensive experience in DUI defense on both sides, both as a prosecutor and as a defense attorney. So, how did you get into DUI defense?
well, it was really kind of a natural transition. I retired from full-time prosecution in December of 2021. And at that time, my good friend John Steakley and his wife Rosie have a criminal defense practice, but John never was a misdemeanor prosecutor, so he never prosecuted DUIs. And he was getting all these referrals for DUI defense, but he really didn't have the expertise to handle it because it is kind of can be complicated. So he brought me on and to do his DUI defense and all cases in certain counties that are in outlying areas. So for the most part, I do the DUI defense in the firm. And that's because as 18 years as a prosecutor, I prosecuted DUIs. And so I know what it takes to win a DUI case at trial. And I know when the prosecutor doesn't have all the evidence he or she needs for successful prosecution, because it's standard of beyond a reasonable doubt. And that's very, very high standard. It's not beyond all doubt, but beyond a reasonable doubt that that person was guilty of the crime charged. So as a defense attorney, I can look at the prosecution's case and point out any holes in their case uh, and make them aware of something I see that might be compromising a DUI trial and get a better result for my client. We don't reduce charges to reckless driving. That's not a lesser included of a DUI. However, if a prosecutor feels that they can't successfully prosecute the DUI, they may drop the charge to a reckless driving, which does not have any license consequences. You don't lose your license and you don't go to jail, that kind of thing. And so that's really the best outcome for my clients.
You talked a little bit about some holes in a DUI case or a DUI charge. Can you talk specifically about what those holes would look like in a case?
Well, in one incident report that I can recall, there was a check mark on the incident report said that a blood test was given. However, no blood test was given. So if that were to go to trial, I would cross-examine the officer on why there's a big mistake on his incident report. And what else did he make a mistake on? And it goes downhill from there for the officer. So I was able to point that out to the prosecutor. I said, we don't have a blood test. He's just used a form and filled in the blanks, but it's not really necessarily for my particular client. And that doesn't look good. And so I would like a reckless driving. And I did get that. Another thing is, how was the stop effectuated? An officer has to have reasonable, articulable suspicion, those are the buzzwords, to stop a citizen and investigate further for something he may think is wrong. I had one case where the officer had no reason to stop my client, none at all, had never seen any bad driving, had just gotten information from a third person that she'd had a margarita at a bar, and he stopped her and did a DUI investigation. I was able to get that entire case dismissed because of improper uh, law enforcement actions.
Speaking on stops for a little bit, I'm getting ahead of myself on the list, but I really wanted to ask you about DUI checkpoints. Now, I know that checkpoints are legal in Georgia and they do occur. Can you talk a little bit about the restrictions on checkpoints, how they're supposed to be operated, and maybe some common violations that on the law enforcement side that take place that could get a case dismissed?
We used to have a lot of roadblock cases when I was a prosecutor, but the hoops that have to be jumped through are quite extensive, and not all police departments knew what those hoops were. And so they violated case law in terms of having set up their roadblock. On a roadblock, all the officers on site have to be identified by either, law enforcement or the bright yellow jackets and cars with the lights flashing. Also, the officers have to be certified in DUI detection, investigation for DUI. There has to be a supervisor on scene that authorized the roadblock, and that has to be in writing. And when they have a roadblock, they cannot let traffic back up. So, in other words, if they're stopping every car they say it's for a license check and insurance, and that is what they're doing, but they're also seeing if they smell any odor coming from the driver. And if the cars back up an unreasonable length, of course, that's subjective, then that negates the whole thing. They have to let the traffic flow through. So if you're lucky enough to be in the back of the line when they got, 5 cars or 10 cars in front of you, they're going to stop the roadblock and let those cars pass through. So, um, yeah, those are the things we would look for as a prosecutor, also as a defense attorney. However, I have yet to come across any roadblock cases in my defense practice. That's because they quit doing them. And I think it's because the supervisor who authorized the roadblock had to come to court and testify. And they're like, I don't want to come to court. So it was a real hassle to get those people in for a trial. And I think that agencies just said it's just too difficult. We're just going to stop doing them.
Can I ask how many cases have you had in your career? Do you know off the top of your head?
You mean as a prosecutor and a defense attorney?
Yeah, in total. In total.
Total, I would say over 2,000 because every 6 weeks I would get a stack of 60 files when I was a prosecutor, and each file had to be gone through. I had to look at the evidence to make sure it was something that could be prosecuted or should be dismissed. I had to look at the person's criminal history and driving history to make a recommendation for a plea offer, which I did in every single case. And every 6 weeks, that cycle would repeat. So 60, 60, 60.
Wow.
So probably well over 2,000 cases I have looked at. Now, as a defense attorney, you don't have as many cases because you're just defending one person out of all of the hundreds that were charged. So, I have maybe 40 active cases right now. I don't really work full time at this point because I am retired from full time work, but I do work part time, which sometimes bleeds into full time. But yeah, so it's a lot of cases. Prosecutors are very, very busy. They're having to turn over these cases and they're in a hurry. And a lot of times they miss what's wrong with the DUI, like they're just skimming the incident report. And so that's where my job comes in as a defense attorney. I come in and say, hey, look at this, look at that, we're missing this. And they're like, oh, and so then usually they'll try to work something out because there's no reason to bring a case to trial that you may not win. So, and juries are fickle. I've had cases I thought I would had won. I'm like, oh man, I got this in the bag, and they come back not guilty. Or I'd have cases that I thought I've lost this one, and they come back guilty. That's as a prosecutor. And so jurors are very hard to predict what they're going to focus on, especially in a DUI that has so many moving parts. It's like a big puzzle piece. The officers have to stop the person properly. They can't detain them for too long without writing a ticket. And what is too long? Kind of subjective, but case law has gone over that. They have to have probable cause to do the arrest, so that's why they do the investigation. And they may ask, where are you coming from? Where are you going? Have you had anything to drink tonight? Where? How much? When was your last drink? And then they go into, can you step outside the car for a minute and let me do some evaluations to make sure that you're safe to drive? Well, all they're doing really is making sure that you give evidence to the state. So I tell my clients, refuse, refuse, refuse. You're going to go to jail, but you can probably beat the rap if you don't do anything. So the officer will do what's called HGN. He looks for nystagmus in the person's eyes. That's a natural reaction when you have a central nervous system suppressant like alcohol. Your eyes will bounce at maximum deviation when they're pulled over to the side. You can't feel it, but I've seen it in person. I've stood behind an officer when he did it, when I did a ride along. And so it's definitely something that they can see. There's 6 clues on that. So if you get 6 out of 6 clues, it's 3 clues for each eye, then it means the person is possibly impaired. And then they usually ask you to do some physical evaluations. They'll ask you to stand in a certain stance and don't start until the officer tells you to begin, which means that you're probably doing like this because it's hard to stay in that stance. And that's one of the clues. And then they'll demonstrate to you that you have to walk heel to toe, your heel catching the toe of your other foot for 9 steps, take little baby steps and turn around. It can't pirouette or spin, another clue, and then walk 9 steps backwards. That's called the walk and turn evaluation. And then the last one usually is called one leg stand. I call it the flamingo evaluation because you're standing on one foot and you take your foot 6 inches off the ground, point your toe, and keep your arms to your side and count out loud till 30 or till the officer tells you to stop. Most people can't do that sober.
I don't
So
think I could.
I know I can't at this age. So it's the thing is, and I did have a trial one time as a prosecutor. I asked the officer to please come down off the witness stand and demonstrate how he tells the person to do this evaluation. And of course, he was like this. And I assume he hadn't been drinking, so it was kind of like, I was like, as a prosecutor, I was like, oh my God, I shouldn't have asked him to do that. So I think that was a not guilty.
That's incredible. Now,
Yeah.
was there a jarring change or kind of experience when you switched from being a prosecutor to a DUI defense attorney? Was there something like really shocking about that?
Um, No, because I had been a prosecutor for so long, I only had to get used to what a defense attorney has to do, things like file leaves of absence if you want to take a vacation, God love you. And, that my paralegal files all the papers, entry of appearance, and then motions and requests for discovery, requests for videos. Officers sometimes have dash cams and body cams, so you get that video. So it was having to get used to a little slower pace and a lot of begging. As a prosecutor, I told people what was going to happen. As a defense attorney, I begged to get a better deal for my client. So,
Oh, I feel like you just brilliantly summed something up there. That's very well done. Now, DUI is a really emotionally charged topic. When laymen try to discuss it, I feel like the first thing that they do is they want to throw the book at whoever's been charged. And I understand why. Obviously, people that have been charged with DUI still deserve their fair day in court.
sure,
Can you
they do.
talk a little bit about that, well, where that emotion comes from, but also how not all DUI cases are made equal?
Well, they're not made equal because it depends on the department that makes it, the particular officer that makes it, their training and experience, that kind of thing. So there's so many variables with any DUI case. That's why I think, and the judges will agree, that you really need a qualified defense attorney to look at all of these factors to make sure that the person's rights were protected. And sometimes they're not because officers don't know what they're doing. Most officers are really good officers. I rarely have an officer that, violates somebody's rights, believe it or not like TV. But you have to look for that kind of stuff. And most of my clients come in, the first thing they say is, can you get this case dismissed? And my answer to that is I've been practicing 25 years and I've had 4 DUIs outright dismissed of all the DUIs I've had. So the answer is no. I did get one dismissed about a year and a half ago, and then my client got another one. So it's like I can't keep working these miracles. But the clients are upset. Of course, it affects their insurance rates. It may affect their job, their licensing in Georgia, nurses, counselors, teachers, uh, lawyers, that kind of thing. It has many consequences and ramifications. Sometimes in certain cultures, there's a shame factor from your family. Um, and also, if you've had more than one DUI, you may have marital problems from that end of it because the wife says, or the husband says, oh my gosh, you didn't do this again. So it's expensive to hire an attorney. They do have public defenders, which I will say are very good. They're not public pretenders like a lot of people seem to call them. My husband is a public defender and he's an excellent attorney. So, but you really need that. And then the client also wants to know what can you do for me? What can you possibly do for me? And can you get this reduced to reckless driving? Of course, I can't make any promises at the beginning of the case. I only know one side of the story, and that's their side. And a lot of times they're so impaired that they're not remembering everything correctly. So you got to take that into account. So I wait until I read the incident report. Yeah, but people that get good results with an attorney, sometimes they'll say, "Well, I could have done that myself." No, no, you couldn't. You couldn't look at the facts of the case and tell where mistakes were made because you don't know what's supposed to be there. So most of my clients are very grateful for my representation, and that's very encouraging. Some are not, but that's life in general.
A lot of our viewers have been really interested in asking us about underage DUI, which I didn't even think was a thing until we started doing this social media page. And that seems to be the question that's at the tip of everyone's tongue. Is that something that you've seen a lot? People with learner's permits getting DUIs? I mean, that seems rare, but it comes up a
Not
lot.
learners permits, but under 21 drivers. The laws in Georgia are very different for under 21 drivers. Your license is suspended for a whole year. That means no driving whatsoever, which can, really hurt somebody at that age because they love driving. Um, the consequences are bad for, they'll probably owe mom and dad's insurance, and that jacks the rates up, and then mom and dad have to help them pay for it. Sometimes when I have a client that's 20 and going to be 21 within a short amount of time, like 6 months, I can convince a prosecutor to put off the plea until after they turn 21. And that gives them the adult punishments, which to me are softer than what is for under 21 DUI. And that's from age 18. I'm sorry, 18. Yeah, 17 through 21.
Hmm.
I've had some, but I'm happy to say that most of my DUIs are from adults.
Good. How often have you seen in your career any DUI charges for people who weren't drinking alcohol? And I'm not saying other substances, but I've heard of cases of people that maybe took too much cough syrup that could have gotten in trouble. Is that a thing that happens?
Cough syrup usually has alcohol in it, but no, I've never had a cough syrup. But um, when the usually a lot of times you'll have drugs. You'll have somebody who smoked a joint of marijuana, and then they'll go and have a couple of beers. And so combining alcohol and a substance like marijuana or THC has a synergistic effect. It can make you feel more high than if you had just one of those in your system. A lot of times I have just drugs. If an officer doesn't smell alcohol, but there was some impaired looking driving, and the officers have what's called a PBT, preliminary breath test. It's a roadside handheld breath where you blow into a tube, and that comes back and shows the officer what alcohol level they're at. Sometimes it comes back zero point 0. Then the officer will say, okay, maybe it's drugs. It could be marijuana. It could be cocaine. It could be hydrocodone, a prescription drug. You could get a DUI for that, even if you're prescribed that, if it impairs your ability to drive safely. So if they suspect drugs, then they'll ask for a blood test, because a blood test is the best way to determine what exactly is in your bloodstream. If they smell alcohol and suspect drugs, the Georgia Bureau of Investigation will just test for alcohol levels. If it's high enough, over 0.08 in Georgia, then they won't test for drugs. So sometimes you have, 3 DUIs on the accusation, but you can only be convicted of one. Prosecutors tend to throw everything at the wall and see what sticks. Yeah,
Now,
so
the yeah, I'm glad you brought up breathalyzers, because I think in 2021 I read a report from the New York Times that said that there was a 40% margin of error on breathalyzer devices. Now that could be totally off, and I'm glad I'm
yeah.
speaking to you about that. So what do you think
I
about
don't
that?
I don't think it's 40%. As a prosecutor, of course, I always think it's perfect, but those machines are calibrated every quarter by a member of the Georgia State Patrol. And those certificates are kept at the machine. There might be an error point, let's see, a range of 0.02 either way. So if somebody is a 0.08, it could be that they might have been 0.083, or it could be that they were 3 points less than that and under the legal limit, but still very close. But it's not 40% at all. No.
That's good to know. I have one last question for you, and I feel like we went really, really quickly. But my final question: do you have a general list of do's and don'ts for people that may get stopped at a checkpoint or a roadblock, or maybe just pulled over by a police officer suspected of DUI?
You mean from the defense standpoint?
Oh, can we get? Yeah, maybe, let's say defense. Yeah.
I tell my clients to refuse everything politely. If the officer says, "Where are you coming from?" say, "I don't really care to discuss that." Be very polite. Have you had anything to drink? I don't care to discuss that, because they smell alcohol, but I don't admit that. And when they ask you to step out of the car and do fields, say, "No, thank you. I don't want to do these," because in Georgia, you have the right to refuse doing those. You also have the right to refuse a blood test or a breath test. The consequences for that, though, is you may get your license suspended, hard suspended for a whole year if you have a refusal. If you haven't been drinking, I would never do the physical evaluations. I would do the breath test, and maybe you have ketoacidosis or you have something going on that may smell like alcohol, but it's not really. So if you are really haven't been drinking alcohol, then you should take the test to prove that you were not anywhere near impaired. And I had somebody where the alcohol came back 0.04, and he had not been drinking. He had a beer, maybe a beer and a half, and he was way under the legal limit. So that helped him. But I would just say refuse. What people think is that they can talk the officer out of arresting them. That's never going to happen. Never. Once you're stopped, you're going to go to jail. Okay, so quit trying to talk your way out of the officer arresting you. I always say you're going to take the ride, but then you can beat the rap because there's no evidence for the prosecutor to prosecute you with.
Put that on a t-shirt. That was fantastic.
Right.
Really, really great. Well, thank you so much. I mean, I know that kind of went really fast, but that was wonderful. Thank you so much for your time. You were great. I really appreciate you taking the time out of your day to speak with me. So